Okay, let's unpack this fascinating deep dive. We are tackling a foundational problem in contract law it trips up even experienced managers. What happens when you sign a contract with a strict deadline, that deadline is missed, but you, the non-breaching party, you hesitate and don't immediately pull the plug?
That hesitation, that moment of patience, is legally transformative. The source material today centers on a classic construction case, Schenectady Steel v. Trimpoli. It's a perfect illustration of how silence and just continuing to allow performance can fundamentally alter the terms of your contract.
Even if you put time is of the essence in bold letters.
Especially then.
So the mission for us is to map out the rules governing this kind of contract modification by conduct. We need to define exactly when a breach is waived and what steps you have to take to legitimately reassert your right to terminate the contract later on.
To succeed in this deep dive, we have to start at the very beginning and determine the controlling body of law. Is it common law or the Uniform Commercial Code, the UCC? Because the rules for termination and notice are entirely different depending on which one applies. Once we settle that, then we can analyze the three critical stages of performance failure in this case: the initial strict deadline breach, the subsequent waiver, and then the ultimate attempt to terminate the contract months later.
Okay, so before we even get into deadlines and delays, the court had to settle this huge jurisdictional point. Does the UCC even apply to a construction contract that involves both the sale of goods, in this case, structural steel, and a ton of labor for erection and installation?
And this is where we run straight into the predominant purpose test. It's the gatekeeper, really. The UCC, Article 2 specifically, it only governs contracts for the sale of goods. So if a contract mixes goods and services, the courts have to decide which component is the real reason the parties entered into the agreement in the first place.
So how do they actually determine that predominant purpose? Is it just about the dollar value, or is it something more about the final result?
It's a holistic view, but the key question is really this. If you stripped away the service component, would the remaining sale of goods be commercially useless to the buyer? If service is the main thing, and the transfer of title to the goods is just incidental, then common law applies. If the sale of the goods is the main focus, then you're in UCC territory.
Okay, let's apply that thinking to the specifics of Schenectady Steel. The contract said the steel company had to furnish and erect the structural steel for a bridge. So when the court looked at that, what was the primary objective?
The court ruled, and pretty firmly, that the contract was fundamentally about securing the erection and installation of that steel. Think about the commercial reality here. Trimpoli wasn't just buying a pile of steel beams to store in a warehouse.
No, of course not.
They were paying for the complex, specialized labor required to weld, construct, and place that steel into a working bridge. The steel itself, the goods, was deemed, and this is a quote, a mere incident of the overall transaction, a mere accessory to the work and labor to be performed.
So in other words, the cost of the raw materials was secondary to the complexity and skill involved in the construction service itself. And because of that, the court said common law applied.
Exactly. And this conclusion was absolutely crucial. The trial court had initially relied on a UCC provision that requires a party to provide adequate assurances of future performance before they can terminate. But since common law applied, that UCC rule is out. The court had to use the much stricter and more fact-intensive common law rules of termination.
That makes the stakes extremely clear. Okay, now that we know common law is in charge, let's look at the contract itself. It included the most severe time restriction possible. Time is of the essence, with a completion date in 1968. What exactly does that phrase mean under common law?
When you include time is of the essence, you are making that specified date a strict condition. It converts the date from just a typical promise, where a breach might lead to some damages, into a material, fundamental part of the deal. Failure to perform by that date is automatically a material breach. It gives the non-breaching party the right to immediately cancel the contract without any liability. Trimpoli had the absolute right to cancel on December 31st, 1968.
But they didn't. The deadline passed, and the work just kept going until March 1969. Why did Trimpoli's patience erase that strict right to terminate?
And this is the doctrine of waiver. It's so important. Common law says that by permitting the contract to continue after the breach of a strict condition, by not enforcing that deadline, the injured party waives their right to cancel based on that specific date. The legal effect of this is huge. The contract is instantly converted into one where performance within a reasonable time is all that's required.
So once it's waived, the clock essentially resets to a softer, more flexible standard. Trimpoli could still sue for damages for the delay, but they lost that absolute get-out-of-jail-free card the time is of the essence clause had given them.
Precisely. They traded a specific absolute right for a vague standard of reasonableness. And now the main question for the court was whether, after this waiver, Trimpoli could somehow reimpose a deadline, or if the steel company's continued slow performance finally breached that new reasonable time standard.
Let's analyze the sequence of events that led to the final confrontation. First, what were the legally dispositive facts surrounding the March 5th termination?
Okay, the essential facts are these. 1. The December 31st, 1968 deadline was missed because of persistent welding issues. 2. Trimpoli waited until late January, early February 1969, a full month later, to send letters insisting on a definitive schedule. 3. The steel company responded on February 12th with a pretty vague assurance to proceed with all possible speed, but they didn't offer any concrete completion date. And 4. Trimpoli's president visited the site on March 1st, saw minimal progress, and finally canceled the contract on March 5th, 1969.
And what was the core legal issue that the court had to resolve?
The precise legal question was whether, under these common law rules of waiver and performance, the general contractor, Trimpoli, was justified in canceling the contract on March 5th, given that they had already waived the original strict deadline.
What was the four-step legal logic the appellate division majority applied to judge whether that cancellation was proper? Please state the full black-letter rule and break it down into its testable elements for us.
Of course. The court applied a synthesis of waiver and performance rules. They were essentially testing whether a new, justifiable right to terminate had arisen after the initial waiver. The four elements they analyzed were: 1. Waiver. Did the injured party waive the original strict deadline? 2. Conversion. Was the performance requirement converted to a reasonable time? 3. Restoration by notice. Did the injured party try to restore timeliness by providing notice requiring performance within a reasonable time? And finally, 4. Failure of reasonable performance. Did the performer then fail to comply with what was expected under that reasonable time standard?
Thank you. Now let's apply the court's thinking to the first two steps. How did the court apply the first element waiver and the second element conversion to reasonable time?
The court found this part pretty straightforward. By not canceling on December 31st, 1968 and allowing work to continue, Trimpoli indisputably waived the strict deadline. I mean, that's settled precedent. And because of that, the contract was immediately converted into one requiring performance only within a reasonable time. The case was no longer about a failure to meet a specific date, but a failure to demonstrate reasonable progress.
Understood. Now for the crucial third element, restoration by notice. The appellate division majority focused heavily on those letters from January and February. How did they argue that those letters helped Trimpoli?
Right, the majority saw these letters as meeting the necessary condition to justify the termination. They viewed the letters, which demanded a schedule and threatened to get other contractors, as sufficient notice that restored timeliness. In their view, this act put the steel company on alert that their window of reasonable time was closing, and closing fast, and that they needed to act decisively or face cancellation.
So, the majority believed Trimpoli had followed the correct common law procedure to transition the contract back from vague reasonable time to something like strict performance required soon.
Yes, that was the appellate division's central claim. And this led them to the final step. How did they analyze the final fourth element failure of reasonable performance leading up to the March 5th cancellation? The court really weighed two primary factors here. First, the appellant's response to the warning letters was, frankly, inadequate. A vague promise of all possible speed is not a definite schedule, It showed a lack of commitment. Second, when Trimpoli's president visited the site on March 1st, the observable lack of progress, combined with that history of delays, it just cemented the court's determination. They concluded that, given the history and the explicit warnings, a reasonable time had certainly elapsed.
And what was the court's final conclusion?
The appellate division concluded that the steel company had failed to perform within the required reasonable time, which had been adequately established by the demands and the visible lack of progress. Therefore, the general contractor's cancellation on March 5th was a justified termination.
Okay, here's where it gets really interesting and, frankly, a bit complicated. The case goes up to the Court of Appeals, New York's highest court. They upheld the cancellation, but they explicitly distanced themselves from the lower court's analysis. Wait, so the lower court was actually wrong in their legal reasoning, even though they got the right outcome?
That is precisely what happened, and it is the single most valuable lesson in this case. The appellate division used language suggesting that the warning letters reimposed the initial strict time is of the essence standard. The Court of Appeals categorically rejected that reasoning.
Okay, let's unpack that policy distinction. If you waive time is of the essence, why is it so difficult to get that strictness back?
Because the law really doesn't want to encourage ambiguity. Once you forgive a strict deadline, the performing party relies on that new, softer standard of reasonable time. To fully reimpose the strict time is of the essence standard, common law usually requires very clear, unequivocal notice that sets a new, definite deadline, which itself must be reasonable under the circumstances.
That's a really high bar.
It is. The Court of Appeals said the letters in this case did not meet that high bar to truly reimpose the strict condition. Instead, they stressed that the initial waiver meant only the lesser standard of reasonable time applied. The steel company lost, not because Trimpoli had perfectly reimposed the strict deadline, but simply because the steel company had already breached the low bar requirement of performing within a reasonable time after the general warning.
So the general contractor won on a lower, easier standard of proof. The key takeaway is that once time is of the essence is waived, it is incredibly difficult to get back. You are then operating under a reasonable time standard, and you have to use clear notice to terminate based on the breach of that reasonableness.
That's the nuance, exactly. Trimpoli's letters demanding a schedule didn't magically restore the right to cancel on March 5th. They just helped prove that by March 5th, the steel company's continued lack of progress was definitively unreasonable.
That makes the shift from strict condition to reasonable time really palpable. Okay, let's use your pizza oven hypothetical to lock this down. You hire a contractor for a custom outdoor pizza oven, stipulating completion by July 1st for a massive party. Time is of the essence. July 1st passes, the oven is half built. You complain, but you let the work continue on July 2nd and 3rd. On July 4th, the contractor is a no-show, so you cancel. Was that cancellation justified?
In that scenario, your cancellation is likely improper. The initial strict deadline, July 1st, was definitively waived by your conduct of allowing performance to continue. Now, the contractor only owes you performance within a reasonable time. Canceling on July 4th, just 3 days after the original deadline, is almost certainly not a breach of the reasonable time standard.
So to make the cancellation legitimate, what would I have needed to do on July 3rd?
You would need to send a clear, non-ambiguous notice. Something like, I have waived the July 1st deadline. However, due to your delay, I hereby require performance to be completed by a new, reasonable date, say Friday, July 8th. If the project is not complete by this new date, the contract will be terminated. Ked, the law demands that clarity if your patience runs out. Without that specific subsequent notice, you're stuck trying to prove that 3 days was somehow an unreasonable delay, which is a tough argument to win.
That clarity is the difference between a successful termination and, well, facing a breach of contract lawsuit yourself.
Absolutely. The law rewards patience, but it demands clarity if that patience runs out.
That's a powerful tool. So to synthesize all these rules into an actionable checklist for anyone listening, what is the step-by-step framework you should use when faced with a contract termination problem involving delay?
Okay, think of this as your 5-step test for every single termination issue like this. 1. Jurisdiction check. First, what law controls? Is the contract mainly for goods, which is UCC, or for services, which is common law? Apply to the predominant purpose test. 2. Initial deadline breach. Was there an express time is of the essence clause? If yes, and the date was missed, the injured party had the immediate right to cancel. Period. 3. Waiver determination. Did the injured party let performance continue past that deadline? If yes, the strict deadline was waived. The contract is now a reasonable time contract. 4. Reimposition attempt. This is the hard part. Did the injured party send notice trying to restore a strict deadline? Remember Schenectady Steel, this is very difficult to do. That notice primarily serves to define the limits of what reasonable time means going forward. And 5, reasonable time analysis. Regardless of a full reimposition, just analyze the conduct. Did the performer fail to meet the reasonable time standard, considering the project delays and their own assurances? If they fail this lower standard, termination is justified.
That structured approach ensures you hit every legal landmark. So what does all this mean for a manager trying to enforce deadlines in a complex environment like construction?
It means that if you include a time is of the essence clause, it's not a bluff, it's a trigger. If the deadline passes, you have to be prepared to enforce it immediately. Any hesitation transforms that strict contractual right into a standard that is infinitely more difficult to litigate, the subjective standard of reasonable time. And if you allow that waiver, your subsequent warnings must be crystal clear to regain any leverage.
That clarity is what protects you. So here's where it gets really interesting for your own thinking. If the appellate division majority's reasoning had been fully affirmed, that the contractor did reimpose the time of the essence clause, what policy concerns might that create for businesses that have already relied on the other party's forgiveness?
And the final provocative thought for you to mull over. In the real world, after a strict deadline has been forgiven, how clear and specific must your new demand for a reasonable deadline be to completely avoid the risk of a countersuit claiming wrongful termination? Is demanding a completion date enough, or must you start demanding specific, measurable milestones?
Think about that requirement for absolute clarity in contracts, especially when time and money are on the line and you've already given the other side a second chance. Thank you for diving into this critical aspect of contract performance with us.